Hello everyone, welcome to Let's Crack UPSC CSE English. In our crash course targeted for Prelims 2021 Inspire. So in this series, we will cover complete polity section. Yes. So friends, today we'll learn about subordinate codes. Yes, as we have covered various topics like state legislature, parliament, high court, supreme court. Yes, now in today's session we'll learn about subordinate code, which is important part of polity section. Yes, before going to start session, it's my pleasure to welcome you all on Unacademy, India's largest learning platform, where you will get unlimited access for live and recorded classes, structured courses, and live tests. It's me, Rushikesh Inamdar, guiding UPSC aspirants from last 8 years. You can follow me on Unacademy, and also you can join our Telegram group using this link. Yes, friends, Unacademy is providing study material in hard copy like 20 books worth rupees 10,000. Yes, now these books absolutely free with minimum 1 year subscription, and this freebies offer valid till 20th April. So you can go with 1 year, 2 year and 3 year subscription. You'll get these books absolutely free with Unacademy subscription. Yes, we are providing mega subscription offer. So here you will get double benefits like additional time or subscription plan, which means the validity of your courses is extra than normal, which means in 1 year subscription you will get validity till prelims 2022, which means if you will go with 1 year subscription plan, you will get guaranteed validity till next preliminary exam, which will be conducted in 2022, and in 2 year plan you will get to guaranteed validity till 2023. Yes friends, this offer is also valid till 20th April, and do not forget to use code RBI Live to get discount in this subscription offer. Yes, those aspirants are pursuing their graduation or after their 12th examination planning to start their preparation, they can go with our iconic subscription. Yes, it's my suggestion, because in this course, iconic course, they'll get all the features of plus course along with personal guidance, study planner and experts guidelines. Friends, we are providing paid subscription, that is plus and iconic subscription, where you will get 10% discount after using referral code RBI Live. Yes, this code is also applicable for optional subscriptions. We have combo subscriptions as well. Yes, 1 year, 2 year, 3 year subscription. Here also you can use this code RBI Live to get 10% discount. Yes, so friends, Unacademy is providing assistance in the form of loan for UPSC aspirants, which means those aspirants facing financial challenges to start their preparation. So Unacademy will help you to providing loan for your preparation. Just you can visit this link to apply for loan. Yes, we are providing free test series for all aspirants, where we will cover complete general studies and current affairs. Just unlock this test series using referral code RBI Live. These are the new batches for UPSC CSE. And do not forget to enroll yourself for Unacademy Combat. We are conducting every Sunday morning 11 a.m. And now this is available in Hindi medium also. So friends, we'll start today's important topic, subordinate codes. Yes. So, the state judiciary consists of a high court and a hierarchy of subordinate courts. Yes. So these subordinate courts, also known as lower courts. Yes. So the subordinate courts are so called because of their subordination to the state high court, and they function below and under the high court at district and lower levels. Yes, the subordinate courts functioning under the high court at district and lower level, that is tehsil and block and village level as well. So these are the subordinate courts. So constitutional provisions like Article 220, 233. Yes, Article 233 to 237 under the Part 6 of Indian Constitution. Yes, which make the provisions to regulate the organization of subordinate courts and to ensure their independence from the executive. As we have discussed earlier, the judiciary's independence is important for justice to the citizens. So Article 233 to 237 in Part 6 of our Constitution make various provisions to regulate the organization of these subordinate courts and ensure their independence from the executive and other interference. So the 20th Constitutional Amendment, yes, 20th Constitutional Amendment Act of 1966, which added new article, that is Article 233A, which retrospectively validated the appointment of certain district judges as well as the judgments delivered by them. Yes. So 20th Constitutional Amendment Act 1966, which added new article 233A into our constitution. Yes. Now first, we'll see the provisions how these subordinate courts work as an independent from executive and other interference. So first provision is appointment of district judges. Yes, the appointment, posting and promotion of district judges in a state are made by the governor of that particular state in consultation with the High Court. Yes, the procedure for the appointment of district judges. Yes, not only appointment, also posting and promotion in the state made by governor with the consultation of the High Court of the state. So, a person to be appointed as district judge should have following qualifications, like he should not already be in the service of the central or the state government. Yes, first qualification or criteria is that the person should not already be in the service of the central or the state government. He should have been an advocate or a pleader for 7 years. Yes, he should have been an advocate or a pleader for 7 years, yes, the person should be recommended by the High Court for the appointment as district judge. Yes, these are the qualifications or criteria for the appointment of district judge. Now, again we'll see the appointment of persons to the judicial service of a state are made by the governor of that state after consultation with the State Public Service Commission and the High Court. Yes, so in practice, the State Public Service Commission conducts a competitive examination for recruitment to the judicial service of the state. Yes, this is the second way for the appointment of district judges, where State Public Service Commission will conduct competitive examination for the recruitment of the judicial services of the state. Yes. Now, third provision for the independence of subordinate courts, that is control over subordinate courts. Yes, the control over district courts and other lower courts, including the posting, promotion, and leave of persons belonging to the judicial service of a state and holding any post inferior to the post of the district judge is vested in the High Court. So there is control over subordinate courts by High Court. Yes. Then interpretation. Yes, the expression district judge includes judge of a city. Yes, includes judge of a city civil court, additional district judge, joint district judge, assistant district judge, yes, chief judge of a small cause court, chief presidency magistrate, additional chief presidency magistrate, sessions judge, additional session judge, and assistant sessions judge. Yes, the expression district judge, which includes all these designations like judge of a city civil court, additional district judge, joint district judge, assistant district judge, chief judge of a small cause court, chief presidency magistrate, additional chief presidency magistrate, sessions judge, additional sessions judge, and assistant sessions judge. Yes, all these are the part of district judge. Yes, so the term district judge is widely include all these judges. So the expression judicial service, yes, so the interpretation is one of the important for the independence of subordinate courts. So the expression judicial service means a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. Yes, we have covered all these posts. Yes, these all posts. Yes, the other civil judicial post inferior to the post of district judge, and also we have covered the district judge posts as well. Yes, the fifth provision is application of the above provision to certain magistrates. So the governor may direct that the above mentioned provisions relating to person in the state judicial service would apply to any class or classes of magistrate in the state. Yes, the governor may direct that the above mentioned provisions relating to persons in the state judicial service would apply to any class or classes of magistrates in the state? Yes. So these are the 5 provisions. Yes. For the independence of subordinate courts like appointment of district judges. Yes. Then appointment of district judges through competitive examination conducted by State Public Service Commission. Then control over subordinate courts by High Court. Then interpretation and application of the above provisions to certain magistrates. Yes. Now, after that, we'll see structure and jurisdiction of subordinate courts. Yes, the organizational structure, jurisdiction and nomenclature of the subordinate judiciary are laid down by the states. Hence, they differ slightly from state to state, and broadly speaking, there are 3 tiers of civil and criminal courts below the High Court. Yes. So there are 3 tiers of civil and criminal courts below the High Court. So where, see, this is High Court. Yes. Then District and Sessions Judge Court. Yes. Then under this there are 2 tiers, that is civil side and criminal side. Yes, in civil side, subordinate judges court and municip's courts, whereas in criminal side, chief judicial magistrate courts and judicial magistrates courts. Yes, magistrates court. So these are the hierarchy we can say. Yes. So these are the 3 tiers of the civil and criminal courts below the High Court. Yes, district and sessions judge court. Yes. So the district court is the highest judicial authority in the district. Yes. He possesses original and appellate jurisdiction in both civil as well as criminal matters. Yes. So the district judge is also the sessions judge. When he deals with civil cases, he is known as the district judge. And when he hears the criminal cases, he is called as the sessions judge. Yes, see the difference. When the district judge is also sessions judge. So when he deals with civil cases, he is known as the district judge. And when he hears the criminal cases, he is called as the sessions judge. So the district judge exercises both judicial and administrative powers. Yes, he also has supervisory powers over all the subordinate courts in the district. Yes, he also has supervisory powers over all the subordinate courts in the district. So appeals against his orders and judgments lie to the High Court. Yes, the appeals against district judge orders and judgments lie to the High Court. So the sessions judge has the power to impose any sentence, including life imprisonment and capital punishment, that is death sentence. Yes, the sessions judge has the power to impose any sentence including life imprisonment and capital punishment. Yes, so however, a capital punishment passed by him is subject to confirmation by the High Court, whether there is an appeal or not. Yes. So, see the power of the district judge. Yes. So, below the district and session code, which stands the code of subordinate judge on the civil side and the code of chief judicial magistrate on the criminal side. Yes. So, the subordinate judge exercises unlimited pecuniary jurisdiction over civil suits. Yes, a subordinate judge is also known as civil judge. Yes, that is senior division, civil judge class 1 and so on. So he may also be given the powers of an assistant sessions judge. So in such a case, combines in himself both civil as well as criminal powers like that of a district judge. Yes, the chief judicial magistrate decides criminal cases which are punishable with imprisonment for a term up to 7 years. Yes, the chief judicial magistrate which decides criminal cases which are punishable with imprisonment for a term up to 7 years. Yes. So at the lowest level, on the civil side, the code of Munsif, and on the criminal side, the code of judicial magistrate. Yes, the Munsif possesses limited jurisdiction and decides civil cases of small pecuniary stake. And a Munsif is also known as civil judge, that is junior division, civil judge class 2 and so on. So, the judicial magistrate tries criminal cases which are punishable with imprisonment for a term up to 3 years. Yes. So in some metropolitan cities, there are city civil courts on the civil side and the code of metropolitan magistrate on the criminal side. Yes. For example, in some metropolitan cities, there are city civil courts, chief judges on the civil side and the courts of metropolitan magistrates on the criminal side. Yes, some of the presidency towns have established small causes courts. Yes, so Delhi, Bombay, Calcutta and Madras were formerly called presidency towns. Yes, so these courts decide the civil cases of small value in a summary manner. So their decisions are final, but the High Court possesses a power of revision of their decisions. Yes. So in some states, panchayat courts try petty civil and criminal cases. Yes, panchayat courts try petty civil and criminal cases. So they are variously known as Nyay Panchayat, Gram Kacheri, Adalati Panchayat and Panchayat Adalat. Yes, this varies from place to place, the name of this Panchayat courts. Yes, which try petty civil and criminal cases. Yes, so they known as variously like Nyay Panchayat, Gram Kacheri, Adalati Panchayat and Panchayat Adalat. Yes. Now, we'll see the articles related to subordinate codes. Yes. So Article 233, which talked about appointment of district judges. Article 233A, yes, which was added later on. So validation of appointment of and judgments, etc. delivered by certain district judges. Article 234, which deals with the recruitment of persons other than district judges to the judicial service. Article 235, which deals with the control over subordinate codes. Article 236, which deals with the interpretation, and Article 237, which deals with application of the provisions of this chapter to certain class or classes of magistrates. Yes, these are the articles. Article 233 to 237 deals with the subordinate codes. Yes. Now after that we'll see National Legal Services Authority. Yes. So Article 39A of the Constitution of India provides for free legal aid to the poor and weaker sections. Yes, Article 39A of our Constitution, which provides for free legal aid to the poor and weaker sections of the society and ensures justice for all. Yes, Article 14 and 22 Clause 1, which also make it obligatory for the state to ensure equality before law and a legal system which promotes justice on the basis of equal opportunity to all. Yes, in the year 1987, the Legal Services Authorities Act was enacted by the Parliament, which came into force on 9th November 1995. Yes, to establish a nationwide uniform network for providing free and competent legal services. Yes, these free and competent legal services to the weaker sections of the society on the basis of equal opportunity. Yes, so Legal Services Authorities Act was enacted by the Parliament. Yes, the law was enacted in 1987 and came into force on 9th November 1995. Yes. So the National Legal Services Authority has been constituted under the Legal Services Authorities Act 1987. Yes, Legal Services Authorities Act 1987 to monitor and evaluate implementation of legal aid programs and to lay down policies and principles for making legal services available under the Act. Yes. So in every stage, a state legal services authority, and in every high court, a high court legal services committee have been constituted. Yes. The district legal services authorities, taluk legal services committees have been constituted in the districts and most of the talukas to give effect to the policies and directions of the National Legal Services Authority and to provide free legal services to the people and conduct Lokadala in the state. Yes. So the district legal services authorities, taluka legal services committees have been constituted in the districts and most of the talukas to give effect to the policies and directions of the National Legal Services Authority. Yes, they provide free legal services to the people and conduct Lokadalats in the state. Yes, the Supreme Court Legal Services Committee has been constituted to administer and implement the legal services program insofar as it relates to the Supreme Court of India and the NALSA, that is NALSA lays down policies, principles, guidelines and frames effective economical schemes for the state legal services authorities to implement the legal services programs throughout the country. Yes. So the role of National Legal Services Authority. So the state legal services authorities, district legal services authorities, taluk legal services committees have been asked to discharge the following main functions on regular basis, like to provide free and competent legal services to the eligible persons, to organize Lokadalats for amicable settlement of disputes, to organize legal awareness camps in the rural areas. Yes. So the free legal services, which include payment of court, yes, payment of court fee. Yes, free legal services which include payment of court fee, process fees, and all other charges payable or incurred in connection with any legal proceedings. Yes, providing service of lawyers in legal proceedings, obtaining and supply of certified copies of orders and other documents in legal proceedings. Yes, preparation of appeal paper book, including printing and translation of documents in legal proceedings. Yes, the persons eligible for getting free legal services, which include women and children, members of SC, scheduled caste and scheduled tribes, industrial workmen, victims of mass disaster, violence, flood, drought, earthquake and industrial disasters. Yes, disabled persons, persons in custody, persons whose annual income does not exceed rupees 1 lakh. Yes, in the Supreme Court Legal Services Committee, the limit is 1,25,000. So, and victims of trafficking in human beings or beggar. Yes. So, these are the eligible for getting free legal services in our country. Yes. So friends, here is the reminder. So you can spread this message to your friends and colleagues. So do not stuck at the preparation due to any financial obstacles. So Unacademy is providing loan for UPSC preparation. The features like zero processing fees, 0% interest rate, approval in 2 hours and flexible tenures. Yes, you can use this link to apply for loan. So now chase your UPSC dream with Unacademy. Yes friends. Now we'll continue with subordinate codes, where now we will cover Lokadalats. Yes. So the Lokadala is a forum where the cases which are pending in a court or which are the pre-litigation stage. Yes. So which are the pre-litigation stage are compromised or settled in amicable manner. Yes. So this is the forum where the cases which are pending in a court or which are at pre-litigation stage are compromised or settled in an amicable manner. Yes. Now we'll see the meaning of Lok Adalats. So the Supreme Court has explained the meaning of the institution of Lok Adalat. Yes, like the Lok Adalat is an old form of adjudicating system prevailed in ancient India. Yes, and its validity has not been taken away even in the modern days too. So the word Lok Adalat means people's court. Yes, this system is based on Gandhian principles. So it is one of the components of alternative dispute resolution system. So the Indian courts are overburdened with the backlog of cases, and the regular courts are to decide the cases involving a lengthy, expensive and tedious process. Yes, tedious process. Yes, tedious procedures. So the court takes years together to settle even petty cases. The Lok Adalat therefore provides alternative resolution or device for expeditious and inexpensive justice. So the experiment of Lok Adalat as an alternate mode of dispute settlement has come to be accepted in India as a viable, economic, efficient and informal one. Yes, this is the statutory status for the Lok Adalat. So the first Lok Adalat camp in the post-independence era was organized in Gujarat, yes, in 1982, and the initiative proved very successful in the settlement of disputes. So after that, the institution of Lok Adalat started spreading to the other parts of the country. Yes, so this institution was functioning as a voluntary during that era. So initially, this institution was functioning as a voluntary and conciliatory agency without any statutory backing for its decisions. So, in view of its growing popularity, there arose a demand for providing a statutory backing to this institution. Then, the awards given by Lok Adalats. Yes, this institution and the awards given by the Lok Adalat. Hence, the institution of Lok Adalat has been given statutory status under the Legal Services Authorities Act 1987. Yes, Legal Services Authorities Act 1987, which provides statutory status to the Lok Adalats. So we'll see the benefits as per the Supreme Court under the, yes, the benefits under the Lok Adalat, like there is no court fee, and if court fee is already paid, the amount will be refunded if the dispute is settled at Lok Adalat. Yes, the provision of refund of fees in case of the petitioner already submitted fees, court fee. Yes, so there is no court fee for Lok Adalat. The basic features of Lok Adalat are the procedural flexibility. Yes, the procedural flexibility and speedy trial of the disputes. There is no distinct application of procedural laws like the Civil Procedure Code and the Evidence Act. So while assessing the claim by the Lokadalat, yes, so the parties to the dispute can directly interact with the judge through their counsel, which is not possible in the regular courts of law. Yes, the award by the Lokadala is binding on the parties and it has the status of a decree of a civil court and it is not appealable, which does not cause the delay in the settlement of disputes finally. Yes, the Law Commission of India, which summarized the advantages of alternative dispute resolution in following way, where it is less expensive. Yes, as per the Law Commission of India, which described the advantages of alternative dispute resolution. So it is less expensive, it is less time consuming, it is free from technicalities, vice versa, conducting of cases in law of courts. Parties are free to discuss their differences of opinion without any fear of disclosure before any law courts. Yes, parties have the feeling that there is no losing or winning side between them, but at the same time, their grievances is redressed and their relationship is restored. Yes. So these are the advantages stated by the Law Commission of India. Yes. Now we'll see the permanent Lok Adalats. Yes. The Legal Services Authorities Act 1987 was amended in 2002 to provide for the establishment of the permanent Lok Adalats to deal with cases pertaining to the public utility services. So features this, yes, the salient features of this new institution of permanent Lok Adalats, like the permanent Lok Adalat shall consist a chairman who is or has been a district judge or an additional district judge or has held judicial office higher in rank than that of the district judge and other persons having adequate experience in public utility services. Yes, these permanent Lok Adalats deal with the cases pertaining to the public utility services. So the permanent Lok Adalat shall exercise jurisdiction in respect of one or more public utility services such as transport services of passengers, transport services of goods by air, road and water. Yes, postal telegraph services or telephone services, supply of power, light or water to the public by establishment, public conservancy or sanitization. Yes, services in hospitals or dispensaries and insurance services. Yes, so the permanent Lok Adalats deals with all these utility services. So the pecuniary jurisdiction of the permanent Lok Adalat shall be up to the rupees 10 lakhs, and however the central government may increase the said pecuniary jurisdiction from time to time. Yes, the permanent Lok Adalat shall have not jurisdiction in respect of any matter relating to an offence not compoundable under any law. Yes, before the dispute is brought before any court, any party to the dispute may make an application to the permanent Lok Adalat for settlement of the dispute. Yes, after an application is made to the permanent Lok Adalat, no party to that application shall invoke jurisdiction of any court in the same dispute. Yes. Whether it appears to the permanent Lok Adalat that there exist elements of a settlement which may be acceptable to the parties, it shall formulate the terms of a possible settlement and submit them to the parties for their observations. And in case the parties reach an agreement, the permanent Lok Adalat shall pass an award in terms thereof. Yes, in case parties to the dispute fail to reach an agreement, the permanent Lok Adalat shall decide the dispute on merits. Yes, every award made by the permanent Lok Adalat shall be final and binding on all the parties. Yes, thereto and shall be by a majority of the persons which constituting the permanent Lok Adalat. Yes. Then, after the permanent Lok Adalat, we'll see family courts. Yes, the Family Courts Act 1984 was enacted to provide for the establishment of family courts within the view to promote conciliation and secure speedy settlement of disputes relating to marriage and family affairs. Yes, the reasons for the establishment of separate family courts. Yes, the reasons for the establishment of separate family courts, like several associations of women, other organizations, and individuals have urged from time to time that family courts be set up for the settlement of family disputes, where emphasis should be laid on conciliation and achieving socially desirable results and adherence to rigid rules of procedure, and evidence should be eliminated. Yes, the Law Commission in its 59th report had also stressed that in dealing with disputes concerning the family, the court ought to adopt an approach radically different from the adopted in ordinary civil proceedings, and that it should make reasonable efforts at settlement before the commencement of the trial. Yes, the Code of Civil Procedure was amended in 1976 to provide for a special procedure to be adopted in suits or proceeding relating to matters concerning the family. Yes. So, however, not much use has been made by courts in adopting this conciliatory procedure, and the courts continue to deal with family disputes in the same manner as other civil matters, and the same adversary approach prevails. The need was therefore felt in the public interest to establish family courts to speedy settlement of family disputes. Yes, So now therefore, the main objectives and reasons for setting up of family courts to create a specialized court which will exclusively deal with family matters so that such a court may have the necessary expertise to deal with these cases expeditiously, and thus expertise and expert and expeditious disposal are two main factors to establish such court. Yes. Then to institute a mechanism for conciliation of the disputes relating to family. Yes, to provide an inexpensive remedy. Yes, to provide an inexpensive remedy, to have flexibility and informal atmosphere in the conducting proceeding in the conduct proceedings. Yes. So these are the main objectives and reasons for setting up family courts. Yes. Now we'll see the features. So the salient features of the Family Courts Act 1984. So it provides for the establishment of family courts by the state governments in consultation with high courts. Yes, it provides for the establishment of family courts by the state governments in consultation with the high courts. Yes, it makes it obligatory on the state governments to set up a family court in every city or town with a population exceeding 1 million. Yes, it enables the state governments to set up family courts in other areas also if they deem it necessary. Yes, these are the features of the Family Courts Act 1984. Yes. Now next feature is it exclusively provides within the jurisdiction of the family courts the matters relating to matrimonial relief, including nullity of marriage, judicial separate divorce, restitution of conjugal rights, or declaration as to validity marriage, or as to the matrimonial status of any person. Yes, the property of the spouses or of either of them, declaration as the legitimacy of any person, guardianship of a person or the custody of any minor, maintenance of wife, children and parents. Yes, so the jurisdiction of the family courts related to all these matters. Yes, it makes it obligatory on the part of the family court to endeavor in the first instance to effect a reconciliation or a settlement between the parties to a family dispute. And during this stage, the proceedings will be informal and rigid rules of procedure shall not be applied. Yes, the proceedings will be informal and rigid rules of procedure shall not apply in these cases. Yes, it provides for the association of social welfare agencies, counselors, yes, during conciliation stage, and also to secure the service of medical and welfare experts. Yes, it provides that the parties to a dispute before a family court shall not be entitled as of right to be represented by a legal practitioner, and however the court may, in the interest of justice, seek assistance of a legal expert as amicus curiae. Yes. So it provides that the parties to a dispute before a family court shall not be entitled as of right to be represented by a legal practitioner, and however the court may, in the interest of justice, seek assistance of a legal expert as amicus curiae. Yes, it simplifies the rules of evidence and procedure so as to enable a family court to deal effectively with a dispute. Yes, it provides for only one right of appeal, which shall lie to the High Court. Yes. Yes. Now, after the Family Court, these are the features of the Family Courts Act 1984. Now, after the Family Court, we'll see Gram Nyayalayas. So, the Gram Nyayalayas Act 2008 has been enacted to provide for the establishment of the Gram Nyayalayas at the grassroots level for the purposes of providing access to justice to the citizens at their doorsteps. Yes. And to ensure that opportunities for securing justice are not denied to any citizen due to social, economic, or other disabilities. Yes, the Gram Nyayalayas Act 2008 has been enacted to provide for the establishment of the Gram Nyayalayas at the grassroots levels of the purpose of providing access to justice to the citizens at their doorsteps. Yes, the Gram Nyayalayas will ensure that opportunities for securing justice are not denied to any citizen due to social, economic, or other disabilities. Yes, so reason for the establishment of these Gram Nyayalayas, like access to justice by the poor and disadvantaged, remains a worldwide problem. Yes, despite diverse approaches and strategies that have been formulated and implemented to address it. In our country, Article 39A of the Constitution, which directs the state to secure that the operation of the legal system promotes. Yes, the operation of the legal system promotes justice on a basis of equal opportunity and shall provide free legal aid to ensure that opportunities for securing justice are not to denied to any citizen by reason of economic or other disabilities. Yes, in the recent past, the government has taken various measures to strengthen our judicial system. Yes, inter alia by simplifying the procedural laws, incorporating various alternative dispute resolution mechanisms such as arbitration, conciliation, and mediation. Yes, so conducting Lokadala, it's also part of that. So these measures are required to be strengthened further if we are talking about the various challenges at grassroots level to common man while getting justice. Yes, so our judicial system will simplifying procedural laws to get justice at grassroots level. Yes, the Law Commission of India in its 114th report on Gram Nyalaya, which suggested establishment of Gram Nyalayas so that speedy, inexpensive and substantial justice could be provided to the common man. Yes, the Gram Nyalayas Act 2008 is broadly based on the recommendation of the Law Commission. Yes, so justice to the poor at their doorstep is a dream of the poor, and setting up of Gram Nalas in the rural areas would bring to the people of the rural areas speedy, affordable and substantial justice. Yes. So, after the reasons for the establishment of Gram Nayalas, we'll see the salient feature of this Gram Nayalas Act. Yes, the Gram Nyalaya shall be code of judicial magistrate of the first class, and its presiding officer, that is Nyadhikari, shall be appointed by the state government in the consultation with the High Court. Yes, the Gram Nyalaya shall be established for every panchayat at intermediate level or a group of contiguous panchayats at intermediate level in a district. Yes, where there is no panchayat at intermediate level in a state. Yes, for a group of contiguous panchayats. Yes, the Nyadhikaris who will preside over these Gram Nyayalayas are strictly judicial officers and will be drawing the same salary, deriving the same powers as first class magistrate working under high courts. Yes, the Gram Nyalaya will be a mobile court and shall exercise the powers of both criminal and civil courts. The seat of Gram Nyalaya will be located at the headquarters of the intermediate panchayat. They will go to villages, work there and dispose of the cases. Yes, the Gram Nyalaya shall try criminal cases, civil suits, claims or disputes which are specified in the first schedule at the second schedule to the Act. The central as well as the state governments have been given power to amend the first schedule and the second schedule of the Act. Yes, as per their respective legislative competence. Yes, the Gram Nyayalayas shall follow summary procedure in criminal trial. Yes, the Gram Nyayalaya shall exercise the power of a civil court with certain modifications and shall follow the special procedures as provided in the Act. Yes, the Gram Nyayalaya shall try to settle the disputes as far as possible by bringing about conciliation between the parties, and for this purpose it shall make use, yes, it shall make use of the conciliators to be appointed for this purpose. Yes, the judgment and order passed by the Gram Nyayalaya shall be deemed to be decree, and to avoid delay in execution, the Gram Nyayalaya shall follow summary procedure for its execution. Yes, the Gram Nyayalaya shall not be bound by the rules of evidence provided in the Indian Evidence Act 1872, but shall be guided by the principles of natural justice. Yes, and subject to any rule made by the High Court. Yes. Now, point to be noted, friends. Here, the Gram Nyayalaya shall not be bound by the rules of evidence provided in the Indian Evidence Act 1872, but shall be guided by the principles of natural justice and subject to any rule made by the High Court. Yes, appeal in criminal cases shall lie to the code of session, which shall be heard and disposed of within a period of 6 months from the date of filing of such appeal. Yes, appeal in civil cases shall lie to the district court, which shall be heard and disposed of within a period of 6 months from the date of filing of the appeal. Yes, filing of the appeal. So, a person accused of an offense may file an application for plea bargaining. Yes. Yes. So these are the salient features of Gram Nyayalaya's Act. Now, we'll see the establishment. Yes, the central government has decided to meet the non-recurring expenditure on the establishment of these Gram Nyayalayas, which subject to ceiling of rupees 18 lakhs, out of which 10 lakhs is for construction of the code, 5 lakhs for vehicle and 3 lakh for office equipment. More than 5,000 Gram Nyayalayas. Yes. So more than 5,000 Gram Nyayalayas are expected to be set up under Act, for which the central government would provide around 1400 crores by way assistance to the concerned states and union territories. Yes, here we can see how, with the help of central government, the judicial system will spread all over the country till grassroots with these Gram Nyayalayas. So under the Gram Nyayalayas Act 2008, it is for the state governments to establish Gram Nyayalayas in consultation with the respective high courts. So majority of states have now set up regular courts at taluka level. Yes, and further, reluctance of police officials and other state functionaries to invoke jurisdiction of Gram Nyayalayas, lukewarm response of the bar, non-availability of notaries and stamp vendors, problem of concurrent jurisdiction. Yes, concurrent jurisdiction of regular courts are other issues indicated by the states which are coming in the way of operationalization of the Gram Nyayalayas. Yes, with the setting up of these Gram Nyayalayas, there are various issues. Yes, non-availability of notaries and stamp vendors, problem of concurrent jurisdiction of regular courts, or other issues indicated by the states, yes, which are coming in the way of operationalization of the Gram Nyayalayas. Yes. So the issues affecting the operationalizing or operationalization of the Gram Nyayalayas were discussed in the Conference of Chief Justice of High Courts and Chief Ministers of States. Yes, in April 2013, yes, it was decided in the conference that the state government and High Court should decide the question of establishment of Gram Nyayalayas wherever feasible, taking into account their local problems. So the focus is on setting up Gram Nyayalayas in the talukas where regular courts have not been set up. Yes. So it's all about the subordinate codes. So friends, just have a recap what we have covered in today's session. Yes friends. So subordinate codes. So the state judiciary, which consists of a high court and a hierarchy of subordinate courts, yes, which also known as lower courts, we have covered constitutional provisions for the subordinate courts like Article 233 to Article 237, which under the Part 6 of the Indian Constitution talked about subordinate courts. Yes. Article 233A, which was added into the Constitution by 20th Constitutional Amendment 1966. Then we have covered the provisions for the working of independence of these subordinate courts from the executive and interferences. Yes, where we have covered appointment of district judges through competitive examination by State Public Service Commission, then control over subordinate courts, then interpretation, then application of the above provisions to certain magistrates. Then we have covered structure and jurisdiction of subordinate courts, where we have covered High Court, then district and session judge courts, the same divided into civil and criminal cases, where civil side subordinate judges court, municip's court, and in criminal side chief judicial magistrates court and judicial magistrates court. Yes. Then we have covered metropolitan cities where city civil courts, that is chief judges on the civil side And the codes of Metropolitan Magistrate on the criminal side. Yes, then we have covered in some states, Panchayat courts try to pity civil and criminal cases like Nyay Panchayat, Gram Kacheri, Adalati Panchayat and Panchayat Adalat. Yes, we have covered articles related to subordinate codes, Article 233, 233A, 234, 235, 236 and 237. Then we have covered National Legal Services Authority. So Article 39A of the Constitution of India, which provides for free legal aid to the poor and weaker sections of the society for ensure justice for all. Yes, so the National Legal Services Authority has been constituted under the Legal Services Authorities Act 1987. Yes, the Supreme Court Legal Services Committee had been constituted to administer and implementation of the legal services program. Yes, so insofar as it relates to the Supreme Court of India, yes. Then we have covered the free legal services and also eligibility for getting these free legal services like women and children, members of scheduled castes and scheduled tribes, industrial workmen, victims of mass disaster violence, flood, drought, earthquake and industrial disaster, disabled persons, persons in custody, persons whose annual income which does not exceed 1 lakh, and in the Supreme Court Legal Services Committee the limit is 1,25,000 per annum. Yes, which not exceeding the 1,25,000. Then victims of trafficking in human beings or beggars. Then we have covered Lokadalats. Yes, so the Lokadalat system is based on the Gandhian principles. Then we have covered the statutory status under Legal Services Authorities Act 1987 to Lokadalats. Then we have covered benefits of Lokadalats, then advantage mentioned by the Law Commission. Then we have covered permanent Lokadalats. Yes, the permanent Lokadalats shall exercise jurisdiction in respect of one or more public utility services. Then we have covered family courts. Yes. Then we have covered the features of Family Courts Act 1984. And then we have covered Gram Nyayalayas. Yes, we have discussed the Gram Nyalaya Act 2008 and various provisions, the challenges and the setting up Gram Nyayalayas for providing justice to the grassroots levels. Yes. Then we have covered the establishment of Gram Nyayalayas. So friends, that's it for today's session in our crash course for Prelims 2021. Now, see you in the next lecture with new topic of Indian polity. Now friends, you can join our Telegram group using this link, and also you can get 10% discount using referral code RBI Live. So please like, share and subscribe Unacademy videos. Yes friends. Also, do not forget to attend free test series by Unacademy and also participate in Unacademy Combat we are conducting on every Sunday morning 11 a.m. So friends, take care, keep studying and revising. All the best.